Good morning. Good morning. Happy New Year.
Happy New Year to you too.
Good morning and Happy New Year as well.
Good morning.
Good morning.
Okay, good morning, everyone. Liz, we can get started. And also just to remind everyone, please mute your microphones. We've been hearing a lot of background conversations this morning. We appreciate the business. That's your personal business. So make sure that your microphones are muted. Okay, go ahead, Liz.
Morning, thank you. My name is Liz Kukla. I'm the Board of Zoning Appeals Secretary, and I'm going to read the preamble for you this morning, January 3rd, 2022. Happy New Year. In compliance with notification requirements of the city's open meeting law and section 101-021 of the codified ordinances of Cleveland, Ohio, 1976, notice of this meeting has been publicly posted. All boards and commissions under the purview of the city planning department conducts its meetings according to Robert's Rules of Order. Actions during the meeting will be taken by voice vote. Abstentions from any vote due to a conflict of interest should be stated for the record prior to the taking of any vote. In order to ensure that everyone participating in the meeting have the opportunity to be heard, we ask that you use the raise hand feature before asking a question or making a comment. The raise hand feature can be found in the participants panel on the desktop and mobile version and activated by clicking the hand icon. Please wait for the chair or facilitator to recognize you and be sure to select unmute and announce yourself before you speak. When finished speaking, please lower your hand by clicking on the raise hand icon again and mute your microphone. We will also be utilizing the chat feature to communicate with participants. The chat feature can be activated by clicking the chat button located on the bottom of the WebEx screen. Call-in users can unmute by using *6. Next slide, Drew. All meeting activity is being recorded via the WebEx platform. These proceedings are also being live streamed via YouTube for public view. We have provided a link to the meeting for those who wish to speak on a particular case via our website and email. All requests to speak on a particular matter have been considered. We have also received emails from those who have provided written comments on a particular matter. Back to you, Madam Chair.
Thank you. Go ahead and call the roll, please.
Thank you. Ms. Brown?
Present.
Ms. Barnes?
Present.
Ms. Faith?
Present.
Ms. Britt?
Here.
Madam Chair, we have a quorum.
Great. Moving on. Any postponements today?
We have one withdrawal that you see on the screen, calendar number 21-189 regarding 12945 Lorraine Avenue. Joe Carino, owner, proposed to change the use from auto repair garage to drive-through retail store in a G2 local retail business district. That is in Ward 16. The applicant has withdrawn his appeal as he intends to meet the code. That's all that I have.
All right, great. Okay, Ms. Faith, we can, excuse me, get started with the first case whenever you're ready.
I see that we have a couple of council people present. And I'm looking to see, do we have Councilman McCormick? Or
No,
should we move on to Councilman Casey's?
Yes, move on to Councilman Casey's, please.
All right.
Mine was just withdrawn, so.
Yes, is that's the only one you had,
Yeah.
Brian?
Yes, thank you very
Okay.
much, Madam Chairman, members of the board. I appreciate you. Thank you.
All right, thank you,
Happy
Councilman.
New Year.
All right, we can go to Councilman Mooney then.
Councilman Mooney, That brings us to calendar number 21-193 at 12017 Emery Avenue. Second Calvary, I'm assuming that's a church. Owner proposes to change freestanding signage to an electronic changeable copy in an A1 one-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinance as stated in the agenda and the public record. With that, to Member Brown for the swearing in.
Good morning. I'm swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do. State your name and your address, please.
I do. Chad Dasher, Westtown Community Development, 10313 Lorraine Avenue.
I do. Brian Mooney, Councilman, Ward 11.
I do. Jason Green with Adam Signs.
I do. Adam Davenport, City Planning.
Actually, everybody, you were supposed to also give your address. Liz, does that matter, or do we need to backtrack?
I think we should go ahead and backtrack. I
Thank
think
you.
Mr. Green is the one.
Mr. Dasher did provide one, I believe. Is that correct?
Jason Green, 1100 Industrial Avenue, Massillon, Ohio.
Keto March, Second Calvary Baptist Church, Cleveland, Ohio, 5915 AMRAP Drive, Parma Heights, Ohio, 44130.
What was your name, sir, that just said that?
Keto March.
Thank you.
Councilman Mooney is 601 Lakeside Avenue. Okay, Madam Chair.
Thank you. Who's going to be a spokesperson today?
Madam Chair, would you like the
Yes.
history?
Oh, I might want that, huh? That's what happens when you're on vacation. You forget the order of the situation. Yeah, go ahead with the history of the property.
Thank you. There's been no change in the zoning for this address since 1929. In the Records Administration Office, I found that in 1928, a permit was issued to erect a church. 1934 and 1960, there were permits issued to, to erect additions to the church. There is one variance on file in calendar 77-361. That's in 1977. A variance was granted to change use of the basement to a daycare for 30 children. And then in the more recent history, in our Acela system, found that in 1994, a permit was issued to install 84 linear feet of 6-foot-high fence with a gate. And that's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting permission to operate an electronically changeable copy sign in a residential district. Can you hear me?
Yes.
Okay. Section 350.13G of the zoning code requires Board of Zoning Appeals approval for an identification or bulletin board sign using electronically changeable copy to display information pertaining to a community facility, and provides the board may grant a variance for such sign if it determines that the sign will provide community information without adversely affecting the character of nearby residential properties in accordance with the following provisions. Information on the sign must be limited to that which pertains to the community facility at which a sign is located. Each display of information must remain static for a minimum of 20 seconds, thereby prohibiting flashing, scrolling, animated, or other copy that gives the appearance of motion. The sign must be a wall sign or freestanding sign with the electronic display area not exceeding 30 square feet in area. The placement and design of the sign must be approved by Planning Commission or Landmarks Commission as applicable, using design guidelines established by the zoning code and with the intent of ensuring compatibility with the character of nearby residential properties. A sign which varies from these provisions may be approved if it receives Planning Commission and Landmarks Commission approval and will meet a community need without adversely impacting the character of nearby residential properties.
Everybody was out in a car.
All right, can you mute that person or whoever that is? Keep getting background interference. Thank you. Okay, now who's going to be the spokesperson for this case? Hello? I got 4 people that's sworn in. Who's going to speak?
Who were you addressing? I'm sorry.
I need to know who's going to speak for this case.
My name is Jason Green with Adam Signs, 1100 Industrial Avenue of Massillon, Ohio, and I'd be happy to.
All right, go ahead.
We are.
Before you start, Jason, you have permission from the owner?
Yes.
Yes, ma'am.
Okay, all right, go ahead, continue.
We are looking to take the sign that is currently there, and actually half of the sign would still address the name of the church, and the bottom of the sign would be electronic, so it would now enable us to be a more active part of the community by applying messages that actually bring information to the community. So we're looking, the church has been around a long time, and we want to continue to be around a long time, and the progression of technology will certainly enable that for us. So we request for us to be able to have an electronic portion below so that we can continue putting information out more efficiently into the community.
So I'm looking at the drawings here. Will the sign be the exact same size as the existing sign now? It's just the facing of it will be electronic. Is that correct or no?
Yes, the overall would be almost identical. Just the electronic would be, as it is in the picture. I don't have a great connection, so I apologize. I'm missing a little bit and piece of a word here and there.
Okay, so can you just describe can you see the sign that we have up on the screen now that you submitted?
If you could just one more time, I really appreciate it.
I said just describe the sign so we can hear, what's going to happen with it. So just describe, the size of it, what's going to run on it, that kind of thing.
Well, the sign actually would be even smaller. The new sign would be 6'10" long, where the old one was 8 foot long, and the old one was 5 foot tall. The new one would encompass 4'11". 2'11" would be electronic, and then 2 foot would be in the header itself.
And what will be shown on the screen while it's illuminated?
Yeah, on the bottom portion would be messages such as activities going on in church. It could be food drives. It could be clothing drives. It could be something going on in the community itself, such as festivals, things of that nature. It would be holidays. It may be anniversaries, things of that nature.
Great. Okay. Thank you. I'll go to Chad at West Town, please.
Good morning.
Sorry. Oh, okay. Yeah, go ahead.
Yeah, Chad Dasher, West Town Community Development. We'd like to express support for this project. You can really look at where this is located, although it is single family parcels. It is really sandwiched in by a lot of local retail and general retail uses. It's not really on the part of the street that directly affects the houses. And just on top of that, the size of the sign isn't changing. It actually is changing. It's actually getting a little bit smaller. And with the amount of information that churches and other organizations have to put out these days, it's just not realistic to go out there and change the marquee letters anymore. It's really important for these institutions to get their information out to the community as fast as they can, and this is the fastest way of doing it. A lot of churches in the city, outside the city, are going to this method. I don't see why Second Calvary should not be able to. And like I said, here at Westtown, we support this variance.
Thank you, Trent. I'll go on to Adam Davenport, please.
Thank you. We're also in support of this. I think the confusion here is that the address is on a residential street, but the property is also located on a commercial corridor. And we've been supportive of electronic signs for churches in the past. Thank you.
Thank you. Councilman Mooney?
Thank you. I think that I did have spoken to Pastor Marsh. I've spoken to Garland from the church and Jason from the sign company and Adam Davenport and Chad Dasher. I mean, I think that they had thought this was because their address is on Emory, but the sign's going to be on Bel Air. But really, it's an A1 single family. The church was built on single family. That's the reason why we have to go through zoning. I think this church is integral to the neighborhood. Like I said, the sign's going to get smaller. It seems reasonable. It's going to be on Bel Air, and I'm fully in support of this. Thank you.
Thank you. Pastor Marsh, did you want to add anything or?
Good morning. Thank you for your time. Our church has a rich history in the community, almost 100 years. It'll be 100 years next year in 2023. I think these gentlemen have pretty much summed up everything. We are a pillar in the community, and not just for those within the church, but we actually serve the community. From coat drives for children, we've adopted schools in the neighborhood, food for children twice a month, feeding families monthly. So my appeal is that we would be permitted to place the sign up. It is smaller, and it would also help us get information out much faster than what we are.
All right, thank you. Okay, I'll open it up to the board for any questions, comments, or motion.
Madam Chair, if none of my colleagues have any questions, I'll move forward with the motion. All right. Given the support of Councilman Mooney, the Westtown CDC and city planning, of note, the sign does face a commercial corridor, and also of note that is actually reducing in overall size. My personal observation recently actually has been that that many churches here on the west side, in Lakewood, Rocky River, and the west side of Cleveland, are making the change to these electronic signs for the reasons that have been stated, that it does lend advantage to getting message out to the community members. So with all that taken into account, and we have thorough support of this, I move that we go ahead and support these variances.
Thank you. Can I have a second?
Member Brown, I second.
Ms. Brown, second. Go ahead, call the roll, please, Ms. Cooper.
Thank you. Ms. Barnes?
Ms. Barnes, yes.
Ms. Brown?
Yes.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Calendar 21-193 is granted. It'll be ratified next week, and we will send the appellant a letter.
All right, thank you. Good luck.
All right, Madam Chair, moving forward. We have a BZA bundle with calendar number 21-184 and calendar number 21-185. This involves 2312 West 5th Street, both the front and the rear buildings. Andrew Gottlieb, owner, proposes to erect a 4-story single-family residence with attached garage in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinance as stated in the agenda and the public record. For 184, we have 4 variances. For 185, we have 5, and all of similar reasons. So with that, I'll hand it to Member Brown for the oath.
I am swearing in all who are present for this case. Do you swear or affirm that the testimony you are about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, then state your name and your address, please.
I do. Andrew Gottlieb, 3187 Old Brainerd Road, Pepper Pike, Ohio, 44124.
I do,
Donna
Donna.
Cornerstone Architecture, 1151 Sherbrooke Drive, South Russell, Ohio.
I do, Donna Gregory, 08 Lorraine Avenue.
I do, Adam Rosen, attorney for Key State Development, Trasker Rosen Fowler, LLC, 5900 Detroit Avenue, Cleveland, Ohio.
I do, Tony Coyne and Catherine Weber. We represent Daniel Raymer. He's a next door neighbor. Our offices are at 1001 Lakeside Avenue, Cleveland, Ohio, 44113.
And I do, Daniel Raymer. I live at 2318 West 5th. I'm adjacent to the property in question.
Good morning. My name is Donna Joy. My address is 2337 West 6th. So I am the length of the other side of the proposed property.
Thank you. Madam Chair, everyone's sworn in.
Thank you. History of the property, please.
Thank you. This address was originally zoned general retail in 1929. In 1987, it was changed to two-family. In the records room, I did not find any relevant permits for this address. There are no variances on file. And then in the more recent history in our Acela system, a permit was issued to demolish a one-family dwelling unit to correct condemnation notice. And that's all that I have, Madam Chair.
Thank you. Legal standard, please. You might be muted, Lori.
Sorry, I hit it, but not hard enough. The appellant is requesting area variances from the minimum lot area, minimum lot width, maximum gross floor area, front yard, rear yard, and side yard requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting the variances will not be contrary to the purpose and intent of the zoning code. Please note that section 32904C may limit the board's ability to grant the requested front yard setback variance, which I understand is in case number 21-185. The other case, 21-184, based on information at a staff meeting, number 2 in that case, which is front yard setback, has been withdrawn or is no longer needed. For some reason, the appellant can explain that.
Okay, thank you. Before we get started, Liz, am I going to ask Shannon about this front yard setback before we get moving?
Yes, I think you can. Shannon, are you available to speak now?
Yeah, so the front yard setback, they either have to be within the average of 150 feet to the north and to the south of the property in each direction, or that there has to be something particularly different about this lot compared to the other lots. In this instance, As noted, you can see that it's a little bit, it's shorter than the lots to the north west as well as the southeast slightly. So that's one of the considerations that can be taken into consideration when you consider whether this front yard setback should be granted in this case.
Okay, so from what I'm hearing, and if we take it into consideration that we can't rule on it, because I like to front yard setbacks. I like to get that out the way first before we get started. Okay.
Yes.
Great. So who is the spokesperson for the project?
I am Adam Rosen will be speaking on my behalf, and Gary Neal is the architect.
And who just said that?
Andrew Gottlieb, Key State Homes.
Andrew. Okay. And so Adam will be your spokesperson?
Correct.
Okay. All right. Go ahead, Adam.
Thank you. Good morning, board. I'm here today on behalf of Key State Development. They are a family-owned home builder that has been building homes for several decades now in and around the Cleveland area. This particular lot has been under Key State's control since about 2015. It is a City of Cleveland land bank lot. And there's been a long history that was shared with the board in a letter sent last week. And I don't think it's a good use of our time to necessarily recap all of those facts and winding through the various approvals and things that have happened so far. However, I do want to fast forward to early 2020 when Key State began to secure approvals for this home. They appeared before the Tremont Central Block Club and did numerous revisions to the design of the units to accommodate the requested variances. And they also appeared before the Tremont CDC's Economic Development Committee to do the same. Both the Block Club and the Economic Development Committee authored letters of support for this project. There were some conditions that I believe Key State has met to comply with variances and other requests to alter the design. And I believe the architect here, Gary, can speak more specifically to what those revisions were and what the final design is today. I think regardless of whether or not the issue of an easement comes up to the next door neighbor, it is not privy to, I believe, the discussion here before the board. The variances requested are of similar nature and character to a number of homes on this street and throughout the Tremont neighborhood. And Councilman McCormick has also expressed his support for these variances. So I'll now turn it over to Gary to talk a little bit about the design, and we can go from there. Thank you.
Thank you. Go ahead.
So, I'm sorry.
No, I said go ahead. Sorry.
Oh, okay. So the concept here is that we're going to have be two units on this property. The design has been well received. We worked through trying to meet many of the requirements that with the design local design community. We felt that this is a way to provide an attractive single family house at the street frontage with a carriage house style home in the rear to create some density within the community, which is bringing an enhancement to the city with density. I know that that's a big issue with the city of Cleveland. So we've kept the square footage as tight as we can to make this work, and I feel that we have I guess I would say we jumped through a lot of hoops to make this thing work as well as possible. Andrew, is there anything you would like to add into that?
Yeah, I would just like to add, we are using we worked very hard with HDRS throughout the
Andrew, and anyone, before you start speaking, just state your name because we have a reporter that keeps this stuff. So just say who you are before you speak.
Sorry, Andrew Gottlieb, Key State Homes. Yeah, so we worked really hard with HDRS over the years to design a home that was appropriate for this neighborhood. This is like our 4th or 5th rendition of this design. We moved the house setback per the request of the neighbors. They actually were very visual, did a great chart for us showing us why they thought the home should sit farther back. So we listened in on that. At one point when we were going through the land bank process of purchasing this lot, it's actually been quite a journey over 10 years. We were working with Sammy Katana on the project prior when he was at Tremont. May he rest in peace. And we were asked to do 2 units. The city actually deed restricted the property for 2 units. And we are making significant investments in the city within Tremont. So we are very excited about this project and teeing it up with the rest of our projects. 1 street over. So we feel like the smaller unit is a good source. Sadly, the downside about this project is our lot isn't as long as the other lots. But as you can see, but we did accommodate the smaller home based off of what HDRS recommended prior to purchase of the lot, and accommodated what the neighbors felt feedback was, and we got some good support from the block club that we're really thankful for and took a long time to earn. So I'm excited for this. And
thanks. Can someone speak to the actual variances you're asking for today, please? We've kind of talked about the front setback one, but just go into a little more detail about what the actual variances you're asking for.
Madam Chair, this is Liz.
Yes.
I'm sorry to interrupt, but we should have made a correction at the beginning regarding the description in calendar 21-184. This is regarding the rear building. Section 357.06A regarding a front yard setback being required. That doesn't apply to the rear house here. So number 2 is not required in this case. And that is 357.06A again. Thank you.
Thank you. I thought Lori said that, but maybe not, but I'm glad it's back on the record again. Okay, thanks, Liz. So go ahead and just, address quickly the actual variances you're asking for today, whoever wants to take that on.
Yeah, I can speak to that. This is Adam Rosen again, attorney for Key State. The variances requested, there are 2 calendar matters for this project for the 2 units. And as Andrew alluded to, that was part of the discussion and negotiation with the City of Cleveland Land Bank. And there's a deed restriction that requires 2 units to support density on this street and in the neighborhood. So for both, I'll begin on calendar number 21-184. That's the rear unit. And that's the one that doesn't require the 357.06 setback because it's the rear unit. But there are 3 other variances here. One is for a minimum lot area. Again, we've talked about the size of this lot being smaller than usual, but even if the size of the lot was, like the neighbor, this variance would still be required. And so we're asking for relief from the lot area requirements under the zoning code to accommodate a home here, both in the rear and in the front. Also, we're asking for a required rear yard setback, which is close to the rear lot line, again, speaking to the size of this lot being smaller. And then city planning approval, we believe that is forthcoming administratively. There have already been conversations with city planning, and I believe representatives from city planning are here today, and they could address that. As it relates to 21-185, this is the front house or the main house, again, with the minimum lot area due to the size of this lot and nearly every house requiring this 355-04A. The next one is again on the rear yard, same issue as it relates to the size of this lot and where the homes are situated. So, these are pretty standard as far as kind of how the neighborhood is and the nature of this street and the way the houses are situated. These are small lots, and the house is appropriately sized based on community feedback and what is the character of the neighborhood.
Okay, thank you. I'll move on to Donna Gregonis from the CDC.
Hi, good morning and Happy New Year, Madam Chair and members of the board. Nice to see you again. So Andrew Gottlieb did present his project for 2 single-family homes on the property. He did go before the neighborhood as well. And he also reviewed all the variances for both homes with the Economic Development Committee. The Economic Development Committee of Tremont West did discuss the project, the related variances, and the easement requested by the adjacent neighbor, which has been mentioned. So they do support the variances on both properties, but really request that the city of Cleveland review the process for which the land bank was transferred. The land bank lot was transferred to Key State Homes a few years ago with regard to promise of an easement being provided to the contingent property owner. So it's important to note that the understanding in the transfer of this lot from the land bank lot or from the land bank was that the neighbor would, the contingent property owner would have an easement with the property here with Key State. So Fred or Tremont West added that this committee request that the city of Cleveland review this request made by Tremont West for the easement originally with the property transfer and review this process with Matt Moss, as he is currently the city planner and was formerly involved with these conversations at Tremont West Development Corporation. So it was unanimously approved with that request to be reviewed. Thank you.
Thank you, Donna. And who's is anyone representing city planning today for this case?
Shannon Leonard, City Planning.
Go ahead, Shannon.
So this was, I'm just replacing Maurice for the day. So this project did go through HDRS, and it is my understanding that they were approved through the Housing Design Review Subcommittee. And so city planning supports these variances. They're typical variances regarding minimum lot size, rear yards, and then the front yard setback here. We do believe that they, for the front house, they do have a lot difference to the nearby lots in terms of they're more shallow. And so we believe that that is grounds for them to be able to obtain that setback issue. And so with that, we really have no objections to these variance requests.
Thank you, Shannon. And as of right now, the project is all encompassed in Key State's property, correct? There's nothing going outside of the property lines, correct?
Not that I'm aware of.
Okay. All right. Just wanted to have that on record. Okay. The immediate neighbor, I can't remember what the name is exactly, but if you want to speak on this, please.
Yes, good morning, Dan Raymer, 2318 West 5th. Would like to, at this time, defer to my counsel, Tony Coyne, if I could.
Yeah, I can talk now.
Yeah.
Yes, I'll start off simply requesting urgently that you table this matter. I believe this needs further study. I'll start off with one, this is a public policy issue that the city really needs to reevaluate. Mr. Raymer had received variances to build a carriage house behind his property as well, conditioned upon an easement on this subject property. But more importantly, as mentioned by the CDC representative, the way the lot was transferred was peculiar. This lot had been listed on the county records as a non-buildable lot. And, it technically is a non-buildable lot because these variances, we can talk about them any way we want to. They really don't meet the practical difficulty standard, but we're doing it as a public policy reason because we're trying to advocate for more density in our city. And it is important, but it's a little unfair when you pit one property owner against another one, and you don't really try to work it out in an effective way. Mr. Rosen, Attorney Rosen submits an ex parte letter, which I don't even know what's in it. I do know his development team comes from Russell Township, Pepper Pike, and Chagrin Falls, and they're taking a property that's next door to a longtime resident of the city of Cleveland. And it just seems to me that if we're going to advance this density question, we should really try to do so in a way that's fair to this new developer that's going to invest in the city and also the property owner that lives next door. I also note that the project will need design review approval from the planning department, and it will need lot split approval. The zoning code is not great at handling these, which is why they're dumped on the Board of Zoning Appeals. So I just respectfully would request that, given the history of how the lot was transferred, this could have been either an additional yard expansion, or it could have been developed a little more harmoniously with the surrounding neighborhood. We would respectfully request that it be tabled for further discussion with the developer, Mr. Raymer, a CDC representative from Tremont West would probably be appropriate, maybe Matt Moss. I just think that given the history of the property ownership, of Mr. Raymer's ownership, and the transfer of this property to a traditional suburban developer would seem to me to be worth pursuing. Otherwise, we would object to the variances being granted. And I note that whenever you create these flag parcels, they should be carefully studied. And I think this is one in which the two property owners could and should be able to work it out. They thought they had an understanding some time ago. I don't understand the reason why it didn't get resolved at that point in time, but we would like to take a stab at doing that and request that it be tabled.
Thank you. Ms. Joy, did you want to add anything? Have your name on the list here.
Good morning. Thank you, Madam Chair. My name is Donna Joy. I reside at 2337 West 6th, parcel number 004-19-073. I've been residing in this residence approximately 25 years, and I am aware and appreciate the approach for advancing population density. My concern is that referring specifically to section 357.08, that the rear yard is required, that there is a requirement for a 27.8 foot area, and the appellant is proposing 4.4 feet. My contest is not the variance between the two adjacent owners for certain, but there is a sanctuary that's been created that has a fully established green space. I do utilize for birds, and was working with the towpath person who wanted to make a bird route to keep their flight patterns. So if you would consider that my sanctuary area, which is quite beautiful, would be a benefit by adding green space, which would be minimizing walls and fences, which would be involved in the erection of these, or the erection of these single family homes. So adding to the green space would not only continue the beauty in my yard, but it would be a shared beauty for those involved in the area, which is quickly losing that space. Thank you so much for consideration.
Thank you for coming to the meeting, Ms. Joy. Okay, Shannon or Lori, I just wanted to ask you about, I don't really want to get into this easement argument because I think that's outside of our purview here, but do either one of you all want to weigh in on allegations about the city process right now?
Kelly, this is Lori Wagner. I'm confused as to what the issue is here for the
Me too.
easement.
That's why I was hoping someone could clear it up.
Madam Chair, I was actually going to ask a similar question. Could you at least somebody explain where the easement would be located?
But before that, Lori,
Yeah, the question, are they asking, is the neighbor next door, who I guess would be on the left here, asking for an easement to access his own property? Or are we talking about an easement for the?
If
Okay.
this is Tony Coyne, maybe I could explain. The easement would run between the new proposed homes and Mr. Raymer's home. So if you're looking at the site plan, it'd be to the left, okay?
That's my
The
question.
concept was because Mr. Raymer had gotten full approval to build a carriage house behind his house on June 18th of 2018 by this very same Board of Zoning Appeals. And that was done with the understanding that an easement would be provided to Mr. Raymer. That has not been worked out, unfortunately. And given the fact that the parcel was transferred to a private suburban developer from an adjacent property owner, and given the fact that the variances are very similar, this would seem to me to be a good public policy issue for the board to consider and for the city to help try to work out to accommodate both houses being constructed. If this easement is not provided, Mr. Raymer's house could not be developed either. So this really is a choice of balancing interests. And it just seems to me from a public policy standpoint, since these variances are granted without planning commission approval on design, without the lots bid being approved, it would seem that we should try to work this issue out rather than to end up having a similar objection at the planning commission and then potentially filing a 2506 appeal on it. So we would like to try to work it out with the adjacent property. That's why I started off with the preface. We're simply requesting tabling so that this could be done equitably between the property owners.
I have a few questions here.
Yes.
Does your client have access to his property now?
He does. He has frontage. He has frontage on West Fifth Street.
Okay, he has an underground garage. And when the variance was granted to allow him to build a carriage house,
Yes.
who was the owner of the property next door?
I believe it's this Key State Development.
And so apparently you're saying a representation was made to the board that an easement would be granted. Who made that representation?
No, the project was approved. All of the variances were granted. I think about 9 of them, subject, however, to the easement being finalized, which is not necessarily uncommon, but that did not get done. And then this project came forward the way it is.
Well, the question I have, I mean, it would not be common for the board to be granting variances for a carriage house if there wasn't some indication from the next door neighbor that they were willing to provide an easement.
Right.
And I guess it seems like it's not appropriate to just say, let's table this for an indefinite period of time. What exactly happened to change that?
I think
Had the owner of the property agreed to provide an easement?
Yes, I'm happy to speak to that.
Yes.
This is Adam Rosen on behalf of Key State Development. And Key State did send a letter to the board in advance of this in anticipation of the argument being made on public policy grounds that Mr. Raymer should be entitled to an easement based on conversations that he had over the course of many years with Key State Development and other stakeholders. But as you can read in the letter that was prepared by my client, those conversations did not end in an agreement between Mr. Raymer and Key State to provide an easement. And there was work done in good faith to establish a working relationship to be able to provide an easement in conjunction with Mr. Raymer's desire to build that home. Unfortunately, that did not end up working out. And as several have stated, including members of the board here today, those conversations, as they took place over the course of many years, there is not an obligation as a review of these variances before you today to consider, those good faith discussions and negotiations. And so if Mr. Coyne wants to make a public policy argument, you are free to consider that. However, those are not relevant in our opinion as it relates to the variances before you today. Now, the context is important because it shows that Mr. Raymer wanted to develop the land, and I'm sure he would like to have ownership of the land that we're discussing today. However, that's not the case, and he was unable to reach an agreement with Key State despite good faith negotiations over the course of many years. So I'm happy to answer additional questions as it relates to the easement, but I believe that the easement discussion is not relevant for the variances that are before us today. Thank you.
Yeah, Lori Wagner, I would say to the board that there's no public policy argument that allows the board or any governmental agency to force somebody to provide an easement to their neighbor. And so to the extent you're asking for that, that's not really a legitimate consideration. Of course, as a practical matter, I'm sure the developer and the neighbor's attorneys both know that the neighbor could take you to court and delay it, but it isn't really, the board can't force anybody to give their neighbor
if I could
easement
respond
on their property.
And if I could respond for Mr. Raymond, we're not saying the board should force that. We're asking for a tabling to try to work it out. These aren't real practical difficulties. We all know that. These are public policy considerations that the city has been dumping on the Board of Zoning Appeals for a period of time. There's no property right issue here being denied. The concern is how the lot was transferred to a suburban developer, not to the adjacent property owner. That's concern number one. Concern number two is there was direction where an easement was going to get worked out, or Mr. Raymer wouldn't have spent thousands of dollars on another architectural plan that a prior constitution of this board approved in 2018. And number three, I really do object to an attorney submitting with this client an ex parte communication to the Board of Zoning Appeals when he knows there's an objection to this project. We weren't served with a letter. He starts off the meeting by stating that you don't have to incorporate it into the record. Well, that to me is not fair because we don't know what his argument is. What I do know is Mr. Raymer has been more than willing to work with Key State. We'd like that opportunity to do so. As far as the tabling, I would request 30 days.
Just say on behalf of the board, as counsel for the board, I have not seen that letter either. But there are property rights here, and the property rights are the fact that ultimately this board or the city of Cleveland cannot force the neighbor to grant an easement. The board may certainly take into consideration the history of this discussions and what permission it granted to the neighbor, and decide whether or not a short tabling of the case is in order for discussions to take place. Maybe perhaps the appellant's attorney could address what their position is on that.
Well, we would like to consider further discussion. Key State went silent on Mr. Raymer, which is why we're here. So 30 days would not seem to be an unreasonable request, and give it one more try. I know Mr. Rosen, I'm sure we could sit down and discuss the possibility of doing it. Again, I do come back to the concern I have. Until we change our zoning code, you're putting a lot of variances on the BZA that really don't meet the practical difficulty standard. They just don't. You could put a nice single family house in the front of this property without the back house, no lot split. You could very easily do that. And by the way, with our very generous tax abatement policy, they would do very well with that. So let's be candid. This is really a public policy discussion. I think density is very important. I'm very supportive of the planning staff's efforts to increase density in our great city. But I really think when it comes to these land bank lots and how they get transferred and when these things happen, it seems to me this conversation is worth having. A 30-day continuance is not going to be unduly burdensome on the applicant, respectfully.
Do you mind if I respond, Chairwoman? This is
Please
Adam
go ahead.
Rosen for Key State. Thank
Yes.
you. Yes, this process has been going on for many years, and the delays and the public approvals and all the different boards, HDRS, the Tremont Central Block Club, Tremont West Economic Development Committee, countless meetings with Mr. Raymer and others. This has been going on for many, many years. And the delay would have a substantial impact on my client. And we've had these conversations with Mr. Raymer. They haven't gone anywhere. He has been unreasonable in his demands for an easement for many, many years. And we take objection to any delay requested by the neighbor. I also take objection, on a level on behalf of my client, trying to characterize him as a suburban developer. Key State Development has partnered with numbers of community development corporations in the city of Cleveland for many years. They're building a 42-unit affordable middle market housing project on the east side of Cleveland. They're building townhomes and other single-family homes across the city of Cleveland. This developer is committed to the city of Cleveland and a high-quality product. And during the conversations with the City of Cleveland Land Bank over many years, again, they agreed to provide density at the request of the City of Cleveland to do 2 units here. And so, all of this has come at a good faith and partnership with neighborhood stakeholders and the community. And what we have here, if you allow me to characterize this, is a neighbor who believes he has rights to my client's property, which is not an appropriate conversation, nor is it an appropriate standard for the board to delay or deny any variances that are requested today. Thank you.
Thank you. Lori?
Madam Chair?
Yes, Liz.
Sorry to interrupt. Regarding that BZA case that's been referred to, that's calendar number 18-107. On June 18th, 2018, the Board of Zoning Appeals voted to grant the request in the matter referenced, pending a copy of the required access easement agreement and lot split. We never received those documents, so that case was dismissed on November 25th, 2019. So the variance was never officially resolved or given a resolution.
That's correct.
Thank you, Liz. Okay, Lori. So Lori, my question is, I'm a little uncomfortable with a neighbor asking me to postpone a case for someone else's property. So what's your legal standard on that for the board, actually?
That's within the discretion of the board, and that would be reviewed as to whether that was a reasonable decision. Perhaps the board would take into account how long the discussions have been going on and whether a brief interlude might be productive as far as resolving that issue. Back, to the issue of otherwise, the board should make a decision just based on the normal standards and practical difficulties. And of course, the history of the board, which is to permit density to support the policy of the city of Cleveland, which in fact they did for the neighbor's property in authorizing a second unit. But it's really up to your discretion as to whether you want to do this, have further delay or not.
Okay. All right. I think we've heard all the arguments. I'll let my board weigh in now.
Madam
If
Chair?
excuse me, if I could, this is Dan Raymer. I just wanted to add one last thing before you guys make your decision here. Earlier, it was made the representation that this has been under Key State's control since 2015. I would like to point out the deed did not formally transfer until July 2nd of 2018. So while this was not actually Key State's property at the time, and there were ongoing discussions with Tremont West, with my architect, with the city of Cleveland, And we relied upon those assurances in order to receive this easement. I would not have moved forward with plans for a rear home carriage house on my property if it weren't for the fact that I was relying upon this easement agreement. It was facilitated by Matt Moss with Cleveland, and I would not have gone forward with if it was something that was privately owned at that time. There were discussions about having this easement put into the actual deed transfer, but the direction I received at the time was to effectively attempt to work together in to reach an agreement in good faith, and that has not been able to come about.
Okay,
Thank you.
thank you. Board
Madam
members?
Chair? Yes, Madam Chair, excuse me, with all due respect, Donna Joy. I'm just readdressing 357.08, which I would lose 21, well, there would be a 21.4 feet easement for being requested towards my property. So I still would like to be considered. My question is, I'm new to the process. So I did see section F also, that if I did not receive any notification from Keystone regarding this, which is fine. I just didn't know that there might be an opportunity for us to negotiate that easement. So thank you.
Thank you. Okay, I'm gonna open up to the board if they have any other questions or discussion.
Madam Chair, I have two questions.
Okay.
One is I am asking, would these homes be sold individually or would both be sold to one entity? I hear about a lot split, but it's not done yet. So as I'm mixing these two together, if they're going to be sold separately, would the lot split need to be done before we issue the variances?
Madam Chair, this is Shannon Leonard. So the lot splits process currently is the survey department is behind schedule due to COVID. And so everything can be worked out simultaneously. The building permit, building and housing won't issue a permit until the lot split is completed. So if the variances were granted, they just would not issue the building permits until the lot split was granted. That is how the process has been going as of the last couple weeks.
So how would the lot split affect then the variance number 2 that we eliminated? Is that the one that goes away if there's a lot split, or was that factored in when you all told us we didn't need it? Sorry, it's getting a little confusing for me.
So number 2 on calendar number 21-184 is not needed because it is a rear home. And so rear homes, generally like a carriage house, like the neighbors discussing, generally does not need a front yard setback.
With or without the lot split, is it considered something different when the lot is split?
Mr. Riccardi could chime in here, but I do not believe that it's different with or without the lot split. This is a 2-family district, so you could have 2 single families on one lot, or you could create a lot split. Obviously, the lot split has to be approved by city planning if it is a substandard lot.
Wagner, I just wanted to add to that, and correct me if I'm wrong, Shannon, but I believe the variance for the front yard for 21-184, it is not a function of whether the lot split is granted or not. It's just a function of the fact that that house is located in the rear of the lot. So somebody can build both of these houses and maintain them, but if they're going to be sold separately to 2 different people, then the lot split will have to occur at that point. But the variance itself is not dependent on the lot split.
Thank you, Lori. I appreciate your response.
Is that all your questions, Ms. Brown?
Yes, ma'am.
All right. Any other board members have questions or comments?
Chairwoman, I believe Mr. Coyne's hand is raised. I don't know if that is intentional.
I saw that. I was just trying to get my board members.
Yes, it was, and yes, it was, and I think Ms. Brown's comment was actually
Mr.
spot on.
Coyne, Mr. Coyne, hold on 1 second. I just want to make sure the rest of my board doesn't have any more questions or comments before you speak.
I'm sorry.
No problem. All right. So anyone else, Alana or Lane, any questions?
Madam Chair, I think I expressed to you that I personally would like the benefit of hearing input from Matt Moss, who's not with us today since he's been part of this process for several years now. That would be my request.
Okay. All right, Mr. Coyne, go ahead.
I was just going to mention that Member Brown's comment was spot on. If you did the lot split first, you would need to get this additional variance granted. And much of the discussion on the practical difficulty really is more about design. So planning should look at the design, and the lot split should be addressed. So all the variances are appropriate. Why we do it backwards, I don't know. I don't want to be critical of that part of the process, but I do think that's a factor that should be given consideration. And I would like the opportunity to have Mr. Moss get involved as well and give us a 30-day tabling of this matter again. But thank you for your consideration.
Thank you.
Madam Chair?
Yes.
So regarding the question about the lot split, it's my understanding that the lot split was considered when these descriptions were written up, when the notice of nonconformances were created. You can see on the site plan that was shown earlier that there is a line that's shown on the site plan that there would be a lot split. So, I mean, we can get just more clarification from Rick Riccardi, but it is my understanding that these individual lots were considered when they were reviewed, and that explains why we have two separate cases here and before you today, two separate calendar numbers. That's all that I have.
Madam Chair?
Yes.
So is this matter being reviewed by city planning administratively only, or is it going to the commission?
Madam Chair, I can answer that.
Oh, okay.
Well, historically, they've gone to the commission. I guess I should clarify that or ask Shannon to clarify that. Historically, though, they go to the commission, but they are two separate processes. So the approvals are not contingent upon one another unless that's what the commission, the commission can request that the variances be granted before the lot split's approved. But historically, they've gone to the full commission. It's not an administrative appeal.
And this has not gone to the commission, is that correct?
Shannon Leonard, I'm gonna let Adam speak on this. He's with the Housing Design Review Subcommittee. He is our neighborhood planner for the Far West Side.
Yes, Ms. Brown. So housing cases under 5 units are reviewed with an internal committee composed of neighborhood planners, staff here in city planning, and then the Department of Community Development. And then the lot split considerations for these projects are heard by the full city planning commission. So that's the differentiation that Ms. Kupo was talking about. So the design is in-house, but the lot split is with the full commission.
So, Madam Chair, I think I would be supportive of members' Faith's request about hearing from Matt Moss, and if not him, having Planning Commission approval before we act.
Okay. Someone should submit a motion then.
Madam Chair, to Ms. Brown, thank you for your support on my previous comment. And Madam Chair, I would like to move that we the request has been made that we table this for 30 days. I think that would be adequate time for us to get input from other parties that would help us lead our decision in this, since it's become rather a contentious and escalating matter. I'd like to be careful about how we decide on this.
All right, can I have a second?
Second, Ms. Barnes.
Ms. Barnes with the second. Go ahead, call the roll, Ms. Kukla.
Ms. Brown?
I'm voting on the motion, right? Not, so yes.
Correct.
Ms. Barnes?
Yes.
Ms. Vaith?
Yes.
Ms. Britt?
No.
Okay, there's a vote that's been carried to postpone this case. Madam Chair, to the question about the time frame, 30 days, of course, would put us at the first week of February, and it would be the middle of the first week of February. Our next hearing after that would be February 8th. We do have a hearing on January 31st, which of course would be less than 30 days.
No, let's do February 8th and try not to load up that agenda just in case this runs a little longer like it did today.
Sounds good. Thank you.
Thank you. All right, so we see everyone back here at February 8th.
Thank you for your time.
Thank
Thank
you.
you for your time.
Thank
Thank
you.
you.
Thank you.
So, Madam Chair, last case
Yes.
for today. Calendar number 21-191 at 2268 West 28th Street. Matthew Moss, prospective purchaser, proposes to build a 2-story, 896 square foot single-family residence with attached garage on a 1,628 square foot City of Cleveland land bank lot located in a B1 two-family residential district. The owner appeals for relief from the strict application of the Cleveland Codified Ordinances as stated in the agenda and the public record, of which there are 5. And with that, to Ms. Brown for the oath.
I am swearing in all who are present for this case. Do you swear or affirm that the testimony you're about to give is the whole truth and nothing but the truth? Please raise your hand, reply, I do, then state your name and your address, please.
I do. Wesley Harper, Horton Harper Architects, 812 Huron Road East, Cleveland, 44115.
Anyone else? Okay, Madam Chair.
Thank you. History of the property, please.
Thank you, Madam Chair. And for the record, we do have an authorization form from Matt Moss to allow this person to represent him. So, Madam Chair, there's been no change in the zoning since 1929. I wasn't able to find any records in our records administration office. There are no variances on this address. And in the Aracela system in 2005, there was a violation notice issued regarding exterior maintenance due to a complaint of junk cars and debris on the site. That's all that I have, Madam Chair.
Thank you. Legal standard, please.
Thank you, Madam Chair, members of the board. Appellant is requesting area variances from the minimum lot width, minimum lot area, minimum floor area, rear yard and side yard requirements of the zoning code. To obtain the area variances, appellant must prove that denying the request will create a practical difficulty not generally shared by other land or buildings in the same district, will deprive the appellant of substantial property rights, and the granting the variances will not be contrary to the purpose and intent of the zoning code.
Thank you. All right, Mr. Harper, go ahead.
All right, thank you. The images we have here show the scale of this property. Obviously a very small corner parcel at York Court and West 28th Street in Ohio City. I've been working with Matt Moss to build a small house here for him, just under 900 square feet. And so we think the fact that this is obviously such a small parcel, the variances we're looking for would logically be something we need to get to build anything on this parcel of use. So the site plan shows the home being set back 6 feet from the West 28th Street property line. We would then be building up to the property line with a porch on the York Court property line. There would be a small one-car garage on the western portion of the property with a curb cut onto York Court, which is preferred by city planning and HDRS. So the home itself is 2 stories, what I guess you'd call it a micro home, a very small home. And so it's kind of 1.5 stories when viewed from West 28th Street. And then the western portion of the home is raised to allow a master bedroom on that second floor. So here you can see the eastern facade, which would face West 28th Street. We've worked very closely with the City Land Bank as well as HDRS on getting a scheme that basically meets the requirements of land bank transfer. So we've added planters at windows and along the porch. This is a small budget project, but one we think is could set a good example for small homes in the neighborhood. Here's an image from West 28th Street. Again, a small 1.5 story tall structure. You can see the porch that goes along York Court to the right here, and it would be clad in wood. So the variances that we're looking for related to setbacks, we feel are created by the diminutive scale of the property itself. So we ask for that consideration in your review. With that, I'd turn it over for your commentary and I can answer any questions you may have. Thanks.
Thank you. Shannon, are you representing city planning today for this case?
Yes, Shannon Leonard, City Planning. So for the record, Mr. Matthew Moss is our colleague here in City Planning. This project, I knew you did. Maurice wanted me to say that, so I just wanted to put that out there. So, but yes, so City Planning, HDRS did review this, and this project was approved with Mr. Harper and Mr. Moss. And so City Planning does not object to these variances. Again, it's because the small size. Generally, we're looking for greater variances, but these are mostly smaller variances. And so in that case, City Planning does not have an issue.
Thank you. I'll open it up to the board for any questions or a motion.
Actually, can I see the side that faces York, and what is across the street on York? Is that a garage?
It is, yes. It's a vacant structure that's basically collapsing onto it. So yeah, it's a nuisance in many ways, I would say, but it's not inhabited by any owners or renters.
So does the house go to the property line on York, or does it stop where that other house does and it's the porch that goes to the property line? Just
Correct.
that.
The interior space roughly matches the setback of that home to the west, and it is the porch that creates the 0 lot line, correct?
Okay, thank you. No other questions, Madam Chair.
Great.
Thank you. I'll entertain a motion.
I'd like to thank Member Brown for that clarification. Good question. And so with that, we have the support of City Planning, and we know that this neighborhood is very tight and this is a very small lot. So with that, I move that we go ahead and approve these variances.
Thank you. Member second.
Member Brown, I second.
Member Brown, second. Call the roll, please, Ms. Cooper.
Thank you. Ms. Barnes?
Ms. Barnes, yes.
Ms. Brown?
Yes.
Ms. Faith?
Yes.
Ms. Britt?
Yes.
Calendar 21-191 is granted. It'll be ratified next Monday, and we will send the appellant a letter.
Great, thank you.
Yes, and Mr. Harper, tell Matt that we'll be over for the housewarming as soon as it opens up. I'm just kidding.
Yeah.
I will pass that along. Thank you. See ya.
That is if we all fit.
Right.
Yeah.
It'll be a multi-tiered party.
Yeah.
Once an hour. People
Yeah.
All right. We got any old business, Liz, or no?
Yes, that was sent over to Shannon on Friday.
We have affirmations.
Yeah, you have. I did send a copy to you as well. I know that doesn't.
Yeah, I haven't checked my email in a while, so.
We have a number 1 through 7, Madam Chair, to
Okay.
approve.
All right.
I apologize.
Since we don't have it, yeah, we don't have it on the screen,
Let
but
me pull it, see if I can pull it up.
Would you like me to read the cases or the addresses or anything?
and I think Shannon's gonna get it up now.
Okay, great.
Can you guys see it?
There we
Yeah.
go.
Sorry about that.
Great.
Okay.
All right. So 1 through 7 without objection, board.
Without objection.
Without objection.
Without objection.
All right. I think that's it.
All righty.
Good to go.
That's a wrap for our first
Everyone
hearing
have a
in
great day.
2022.
Yes.
Happy New Year.
Happy New Year to everyone and have a good week.
Happy New
Thank
Year,
you,
you too.
everyone.
Thank you.
You too.
Bye bye.
Bye.